Sarah Norberg lurking outside the door here. So I'm going to hand it over to Sarah. We're a little ahead of schedule.
I hear that. I figured everyone would want to get out of here a little early, so
I hand it over.
Another half an hour on case advisory.
I can keep talking all day.
So if many of you, if you deal with business professions, probably know Sarah. She's one of our DLSC attorneys, and she's going to walk you through for the next hour or so and take some questions on what it means to be a case advisor. Do you need a microphone?
I don't think so. I'll try to speak loudly, just because I'm not sure I can hold that and do all of this. So if you can't hear me in the back, just shout out, raise your hand, and I'll try to speak up. So, welcome. I know you've been here all day, so I will try to get through this as quickly as I can, but I do have a lot of information for you. Excuse me. And I'm suffering through a chest cold, so hopefully we'll make it through this. As Greg mentioned, my name is Sarah Norberg. I'm a lead attorney in the Division of Legal Services and Compliance, and here to talk to you about your role as a case advisor on our disciplinary matters. So, first and foremost, the Division of Legal Services and Compliance is a part of the department tasked with the responsibility of enforcing licensee compliance with state laws and professional codes. We work collaboratively as the board's partner in ensuring that fair and just discipline is imposed on violators of professional rules in a way that accomplishes the state's goals of protection of the public, deterrence, and rehabilitation of the licensee. Within disciplinary actions, individual board members may have two roles. There's a judicial role of a final decision maker, a judge if you will, and the consultant role of a case advisor. And so most of my presentation will focus on the latter. As a consultant, the case advisor of a particular case assists the division's prosecutor with professional expertise on the licensee's misconduct and necessary discipline to bring the licensee into compliance. If the attorney and licensee reach an informal resolution, the board as a whole, including the case advisor, will hear relevant facts as the judge and determine whether the agreed upon resolution is sufficient. The consulting and judicial roles must be kept distinct and separate. To blur the line between those roles violates due process. So I will try to go through some of those issues a little later on in this presentation.
Please stand by.
Technical difficulties. The state of Wisconsin recognizes and respects an individual's interest in earning a living. However, that interest must be balanced with the public's interest in obtaining services that are safe and effective. So, as I mentioned previously, in disciplining licensees, the state has three goals: to protect the public, to deter the conduct, and to rehabilitate the licensee. The state does not punish licensees for misconduct, but provides them with the necessary tools and opportunities to regain compliance when possible. This protects both the public's and the individual's interests. I'm going to take you through the case handling process. The intake stage is the first stage in the intake process. When a complaint is received by the department from consumers, professionals, internal staff, we have intake staff who collects the relevant information, such as records, follow-up from the complainant, if the information is incomplete, a response from the licensee, and sends the complaint to the screening panel, which consists of a prosecuting attorney and members of the board. Usually, I believe you vote and you serve some time on the screening panel. The screening panel will meet at a predetermined time, usually once a month, will confer and determine whether from the information provided a violation may have occurred. The panel may consider many factors such as the seriousness of the allegations, the harm or threat of harm, whether the dispute is already resolved, and whether the matter is primarily a civil matter or a private dispute. If a complaint does not warrant further action, it is closed and a closeout letter is sent to all of the parties. If a complaint does have merit or requires further investigation, the case is open and goes to the investigation stage. The intake stage is especially important as a gatekeeper against trivial complaints and cases without proof. This stage protects licensed professionals from meritless attacks on their reputation and livelihood. In certain circumstances, a licensee may be close to violating a professional standard, but didn't actually violate it. Through the screening process, the panel may choose to remind the licensee of the laws governing or potentially implicated by his or her particular activity in the closeout letter. So this is a little bit about what I talked about. Complaint is received, it goes to the screening panel, can either be closed or opened, and then we continue to the investigation stage. When a case is opened, a case advisor will be assigned along with the division legal team, which will be made up of an investigator, a paralegal, and a prosecuting attorney, and in the case of appraisers, a staff appraiser as well. The advisor can be assigned to a particular case by the screening panel. Sometimes in my experience, if the screening materials have been particularly thick and one of the board members already read those materials, they might volunteer to take the case. So it can happen that way. It can also happen on general rotation, where we just go down the line of board members who are to serve as case advisors. You know, one will get one, the next board member will get the next case. And that assists with even distribution of cases among the board members. Expertise might be a reason that we assign a particular case to a particular board member. In cases where professional expertise is not required, that's generally those types of cases we assign to the public members, so they can assist in this case advisor role as well. Geographical area might be a reason we assign a case. A case advisor is assigned based on not being in the same geographical area as the licensee, except in real estate appraiser cases. And finally, division staff can assign a case to a particular case advisor. This might come up if the case advisor who was assigned has a conflict. Once assigned, the advisor will receive an email or letter from intake staff with notification of the assignment. The notification will include the case number, the names of the parties, and a brief description of the complaint. At this time, the assigned advisor should determine if there is a conflict of interest or bias that would require reassignment. Conflicts of interest include, but are not limited to, a personal relationship with any of the parties in the matter, the complainant, the licensee, if we know there might be any witnesses at that time, or if you have a financial interest, relationship to a firm that's been pulled into the case, competitor, things of that nature. The case advisor must avoid any appearance of impropriety or conflict. And if a conflict does exist, or you're uncertain if one exists, please contact the division's legal staff as soon as possible. So the next stage in the case handling process is investigation. When an investigation commences, the case advisor may be asked to identify materials required in order to make a determination of whether a violation has occurred. During the course of the investigation, the case advisor is consulted to provide expert and technical advice and assistance to the division staff. At the conclusion of the investigation, staff will submit findings of the investigation to the case advisor. In complex cases, this might be a case summary that's drafted by the investigator, reviewed by the attorney, and sometimes might have a recommendation by the attorney already in it. In a simple case, this might just be an email with an analysis and summarization of the facts and the evidence. Your role at this point is to assist the attorney in determining what the professional standards are, if it's not already clear from the statutes and the code, whether the conduct fell below the minimum standards for the profession, and what appropriate discipline might be if a violation occurred. In cases requiring an opinion regarding the facts of the cases related to professional standards, division staff may require an opinion of the case advisor, who serves again in like a non-testifying expert role. While the prosecuting attorney is the expert of the law, the case advisor's opinion is critical on issues involving professional expertise. In straightforward cases, the division attorneys, as I mentioned, may provide a recommendation to the case advisor for approval. Where the evidence is insufficient to prove a violation by a preponderance of the evidence, which is our standard, it's a more likely than not standard, or there are other reasons not to pursue prosecution, the prosecutor and the case advisor, if necessary, will determine the specific basis for closing the case. If prosecution is warranted, division staff will work with the case advisor to determine appropriate discipline. Some considerations in determining discipline include historical practices of the board. We want to be consistent and follow precedent as much as we can. If you're new to the board, the legal staff can help you with this. We have the prior board orders, ability to search those orders, and might just have experience ourselves working with the board. We also are aware if this licensee has been disciplined by the board before. Another consideration would be the severity of the conduct, including the risk of potential harm, and the quality of the evidence with which the prosecutor should be able to aid you with. Also, because the legal team has direct interactions with the licensees, the team may have important insight as to what may be the most efficient and effective way to bring a particular licensee into compliance. But again, discipline cannot be punitive and is limited to actions taken on the license for purposes of protecting the public, deterring the conduct, and rehabilitating the licensee. The end goal is for the attorney and the case advisor to agree on appropriate resolution for the case. Discipline is appropriate for licensees who fall below the standard of minimal competency. The state does not regulate professionals to all operate at the highest standard possible, which is a system better controlled by the market and the individual professional's reputation. Instead, we regulate professionals to operate at the minimum standard. At times, licensees may be careless, incompetent, or reckless. As the embodiment of the profession, boards must make sure that the imposed discipline is appropriate to address the misconduct when the entire circumstances are taken into account. In addition to formal discipline, boards also have non-disciplinary options that may more appropriately correct the licensee's failure. The case must always be reviewed and determined on a case-by-case basis, taking into account all facts specific to the particular case. Some useful non-disciplinary tools are when the incident in question was not seriously harmful to the public. The legal team, including the case advisor, have ability to close cases for what we call prosecutorial discretion. Sometimes the simple act of opening a case and making the licensee aware is enough to bring them into compliance, which is the second one here. Another reason that we might close a case for prosecutorial discretion is when there is litigation, civil litigation primarily pending, which affects our ability to investigate the case. So we have the ability to kind of close that case out, but flag it so that when the civil litigation is concluded, we can take another look. Another form of non-disciplinary action is remedial education. This requires the licensee to complete education that addresses his or her failure through a board order that does not include a specific finding of a violation. This allows the licensee to gain compliance with less embarrassment to his or her professional pride, wouldn't affect practice privileges, but it is published on our website. Another form would be an administrative warning. This requires that the misconduct is a minor violation and a first occurrence of this violation for the licensee. The fact that the warning was issued is a public record, but the content of the warning is private and confidential. Licensees have the ability to request a review of the warning within 20 days, and they'd be able to make an appearance before you and your board. If the warning is appealed, the board may re-examine the case and request the division to pursue a different path. An administrative warning, while not discipline, may be used in a subsequent disciplinary proceeding as evidence of knowledge of the misconduct. I think this is the final non-disciplinary tool, the professional assistance procedure. PAP is an alternative to the formal disciplinary process for impaired professionals. It encourages individuals to seek help for their impairment in a non-disciplinary environment. If an individual is released from PAP for failure to comply with the program, the department monitor may at that time refer the individual to the division for disciplinary proceedings. Now we're on to formal discipline. If the licensee's misconduct cannot be corrected with a non-disciplinary option, or if the misconduct is common enough that all licensees within the profession must be alerted to its substandard nature, formal discipline is warranted. The lowest level of formal discipline that we have available to us is a reprimand, to publicly warn the holder of a credential. Along with a reprimand, we may limit the individual's license. So a limited license means to impose conditions and requirements upon the holder of the credential and to restrict the scope of the holder's practice. A credential can be limited in many ways, allowing boards to creatively and most appropriately address the credential holder's deficiency. For example, you can limit a license with education. Would that meet the purposes of disciplining, which are, to protect the public, but also to rehabilitate the licensee? So if a licensee appears to have violated a rule based on a specific area of the law that they might just not have enough knowledge, you can order them to complete a certain amount of education on a specific or one or more topics within a certain time frame. Along those same lines, maybe they need to take another national exam or a state exam, or whatever types of testing are involved in your profession's license. Assessment and treatment may be another way to limit the license. Supervision, work reports, or auditing might also be considered. The license limitations are somewhat endless. You can limit by practice scope, geographic area, types of procedures, types of clients. As I mentioned, they can be for a certain time period. We just want to make sure that we are drafting an order that is measurable. Can what we want them to do be measured and monitored, so that if they're not in compliance, we can take additional action. And just a note, We cannot order restitution, charity work, anything like that. We have, we've got to have clear statutory authority for the discipline we're imposing. Moving up on the chain of formal discipline to something a little more harsh would be a suspension. To completely and absolutely withdraw and withhold for a period of time all rights, privileges, and authority previously conferred by the credential. Suspension should only be used when the conduct was egregious, as it is a form of deterrence rather than rehabilitation. Suspensions can be imposed by length of time, completion of other board requirements, and we can require them to petition the board to lift the suspension after a certain time frame or certain requirements. The highest level of formal discipline is a revocation. Sometimes we can do it in the form of a voluntary surrender as well. This is to revoke, to revoke is to completely and absolutely terminate the credential and all rights, privileges, and authority previously conferred by the credential. Again, it's only for the most serious misconduct. Now, this might seem contrary to what I just said, that it may or may not be permanent. But sometimes we might feel that they should be out of practice for 2 years, 4 years, and then be allowed to reapply. So whether it be a revocation or a surrender, if they're allowed to reapply, they would need to meet all then existing requirements for initial licensure. So whatever initial education or testing needed to be completed to get a license will need to be completed again. A surrender, it's the same thing, it just generally causes less embarrassment. Then there's a voluntary surrender or a retirement surrender. This might be where a disciplinary matter has been opened and the licensee is near retirement or has decided to pursue another profession and just wishes to stop practicing. We can do these without a formal finding of a violation because these will be permanent. No reapplication here. This isn't moving up the chain of levels of discipline, but some boards have forfeiture or citation authority. I'm not sure I'm aware of a board other than the cosmetology examining board that has citation authority, but a lot of boards and sections have forfeiture authority. Needs to be within the statute. Another option that we have available to us is a summary suspension. Summary suspension is a special tool that allows us to suspend a licensee without a stipulated agreement and before a full hearing is had. Because this tool circumvents due process, it can be used only when the facts establish that the licensee has engaged in and/or is likely to engage in conduct that threatens the health, safety, or welfare of the public, which requires emergency suspension. If a board uses summary suspension, a formal complaint must be filed very shortly after that order goes into effect, and the hearing on that must be held promptly. So if the legal team and the case advisor think this is appropriate, you pretty much need to make sure that you've got all your evidence because very quickly thereafter you're going to be going for a full hearing. Obtaining a summary suspension against a licensee does not necessarily mean that licensee has indeed engaged in misconduct. It only means that we have enough reason to believe he or she did and that they will continue to do so, placing the public in danger. Without evidence that the dangerous conduct is likely to continue unless the licensee is suspended, summary suspension should not be granted. Moving to the next phase of the case handling process is legal action. Disciplinary action may be agreed to by the licensee in a stipulation, and if no stipulation can be reached, discipline can be pursued through the formal hearing process. negotiation. We generally negotiate or try to negotiate a stipulation, a settlement, if you will. It's a proposed agreement between the prosecuting attorney and licensee as to the resolution of the case, and it is subject always to board approval. The division legal staff will consult with the case advisor on a specific settlement offer or a range of appropriate discipline or bottom line offer that is acceptable. By entering into a stipulation, a licensee will be waiving certain rights, including the right to a hearing on the issues. The negotiation process often involves a give and take between the prosecutor and licensee, or the licensee's attorney if they have one, and not every case will end in a stipulation, although I think, just as in civil practice, most do. So if we can't achieve resolution through a settlement, we'll be moving on to hearing. A formal complaint will be filed, and an administrative law judge with the Department of Administration's Division of Hearings and Appeals will be assigned to hear the case. The licensee is given an opportunity to file an answer to the complaint. A hearing date will be set, maybe a few months out, allowing the parties to engage in discovery. It really tracks the civil process. It's just much less formal. The case may still be resolved through a stipulation even after a formal complaint has been filed. If no agreement is reached, then the case actually goes before an administrative law judge at hearing, which is held here at the department. At which time the prosecutor and the licensee or their attorney may present evidence, which includes witnesses and documents in support of their position. The division has the burden of proving by a preponderance of the evidence that a violation of rule or statute occurred. And again, that just means a more likely than not standard. Following the hearing, the administrative law judge will prepare a proposed decision, which is submitted to the board for consideration. So the boards have delegated this fact-finding to the ALJ, but it is ultimately up to the board to decide what should happen with the case. The board will consider the record in the case and issue a final decision in order. The board can either accept the proposed decision of the ALJ, it can reject it, or it can alter it by drafting an amended decision called a variance. There are different appeal rights as well with this. A licensee who's been disciplined after a final order of the board can petition for a rehearing, or actually has some civil court appeal rights, can petition for judicial review to a circuit court. The most important factor in ensuring efficient and effective discipline of a licensee is clear communication between the case advisor and the legal team. The case advisor and legal team assigned to the case should maintain open communication, telephone, fax, email. Just let the legal team know whatever works best for you. And it's an ongoing process throughout the case. The case advisor should provide the legal team with an opinion or request for additional information within 2 weeks of receiving the investigative materials, 3 days for real estate appraisers. The federal government mandates that real estate appraiser cases be resolved within a 1-year time frame from the date the complaint is received, so those need to be handled much more quickly. Timeliness is obviously critical for many reasons. It allows us to conduct an investigation, collect evidence that might be fresh. Licensees obviously want to have their cases resolved as soon as possible. So if the case advisor knows that there might be a delay, you're really busy at work, you're going to be out of the country, please let the legal team know as soon as possible. Confidentiality. Being privy to private and some oftentimes unproven information, the case advisor has the duty to maintain confidentiality. Pending cases cannot be discussed with other board members, colleagues, or friends. Occasionally, an issue may arise that is outside of the certain advisor's specialty or area of expertise. In those circumstances, the advisor may consult with a colleague in that particular field or specialty in order to form an opinion on the violation and appropriate discipline. However, there's two prohibitions on this. The consultation may not be with another member of the board. And specific information in the case may not be disclosed. If questions or other concerns arise, don't hesitate, again, to contact your legal team. Ex parte communications. Case advisors must not communicate with individuals involved in a pending case, including the complainant, licensee, any witnesses, because you're acting as, again, this goes back to the dual role, acting as a judge, acting as a non-testifying expert. It's essential that all decisions and recommendations be made with objectivity. So there, you must protect against conflicts of interest as well as the perception of a conflict. Let me back up 1 second. So we've had this actually happen. If a party to a case, the licensee particularly, attempts to contact you, you have to let them know that you cannot discuss any matters with regard to the case with them, and let the prosecutor know right away. When a proposed resolution, whether a result of a stipulated agreement by the licensee or a proposed decision by the ALJ is before the board member that served as the advisor for the case may or may not be a part of the deliberation and vote, depending on what type of case it is. With proposed stipulations, administrative warnings, or case closures, the case advisor may participate in discussions and may vote on the matter. In fact, the case advisor should be prepared to speak in support of the agreed upon resolution, discipline, or closure. The advisor can always contact the legal team, kind of to refresh your memory if it's been a while since you spoke with the legal team and by the time it's actually getting to the board. Proposed decisions following an evidentiary hearing, this is the hearing before the administrative law judge, you may not participate in discussions or vote on the matter because you likely had access to information that may or may not have been presented, that may or may not have been admitted as evidence during the hearing, and it would be unfair and unjust to the licensee for the advisor to report on things that weren't proven at the hearing. Another special note is case advisors may also need to abstain from deliberations and voting in probable cause determinations. I think that's the medical examining board only, and also summary suspension determinations. All materials you receive during the course of the case, investigation, and disposition are confidential. They should be kept in a secure location and not shared with others. When the case is closed, you may destroy all copies or return them to the division for disposal. I think it's unlikely, but if you think you were provided an original, please make sure that that gets returned to the division. And I just buzzed through that. We want to thank you all. You are just so necessary to the resolution of these cases. Again, we kind of know the legal side of things, but you all are the experts in your own field, and without you, we couldn't do it. So we want to thank you for your commitment to the profession and for your service on the boards.
Any questions for Sarah?
I know that was really a lot of information very quickly. Joe.
Sarah, do you ever see an instance where, because of the nature of a case or situation, where the case advisor recommends the inclusion of an outside expert on this stuff because it may not be in an area that they are familiar with or that they practice?
Yes, and so that goes back to I don't know why, but we refer to it internally as the curbside consult. So if you're not, and hopefully I'm hitting this on this right and understanding you, but this would be where you feel that the issue involved in the case is not really within, I mean, it's within your profession, obviously, but maybe not within your area of expertise.
Right.
You are free to, if you know a colleague or a friend in the profession or someone else, you're able to discuss the issue, just nothing specific, and it can't be another board member. In cases that are, very technically difficult, if we have to go to hearing, you've generally served as the non-testifying expert. We will generally be hiring a testifying expert if need be to go to hearing. Did that answer?
No, that's exactly what I was looking for, because I would think also that a person, because I've been in the case, if does something like that and asks somebody else some questions like that, that should be with the knowledge of the legal team so they know what's going on in this.
Absolutely.
Because if something can get downright nasty and dirty and something, so it's not blindside.
Right.
The case advisor would never be called as a witness, right, in a hearing, or is that?
No, I don't think so. Because you're kind of part of the legal team.
Well, that's what I thought. So, thank
So
you.
you're safe there.
That thing.
That thing.
Could you give an example or two of when a summary suspension has been issued?
Sure, I just had one last month. My first one here. The case involved it was a real estate case, and I actually was I was part of the screening panel, so I saw it very early on. The allegations were theft of large amounts of money from a client in the realm of the licensee's real estate practice. So I was kind of alerted that this might be the way we have to go very early on. So the case was opened at screening. Case advisor was assigned. I discussed it with the case advisor. He agreed, and we very quickly got that investigation underway, and I filed a petition for summary suspension. It's kind of, again, like the civil process or the administrative hearing process, where I didn't file a complaint, but I filed a petition for summary suspension with supporting documents, affidavits, things of that nature. And that goes to the board as the judge. And I was afforded the opportunity to make a presentation to present my case. The licensee was given notice. They can appear. I don't believe they're generally allowed to present a full case, but to make a statement. In my circumstance, he did not appear. And I think we were very concerned because perhaps a large amount of money had been stolen, that the public was at large risk of him, and he's still practicing, so he could do it again. So the board did grant the summary suspension. There are appeal rights to a summary suspension too, which I didn't mention. I hate to get too far down the line for all of you, but they can request an order to show cause, or in order to show cause, which a hearing would be held. Basically what that means is we want the prosecutor to prove why this summary suspension should continue until the full hearing is had. But by the time this gentleman actually filed that, I had already filed my formal complaint. So now it's kind of interesting because we're heading down the formal path to the formal hearing, and then we might have this other thing. So depending on which goes first, might be a moot point.
It sounds like in that case there will also be, there could also be some criminal action too.
Which there is. So I had discussions with the county district attorney handling that case. Wanted, just like, as I mentioned with civil matters, our ability to investigate may be impaired by civil matters. I wanted to make sure I wasn't going to mess his case up, his criminal case, with our ongoings, but it was all fine. So that person is facing felony charges as well.
So with the summary suspension, is for public notice? I mean, is it on the website that the individual's license is? Okay.
And so is it open? Is it open session except for the voting and deliberations? Yeah,
But I mean, if you looked up the credential holder, it would be suspended.
it's suspended.
Sarah, can you walk me through, I had a case where violation there, and is there a statute of limitations? However, I guess I'm talking about the historical being consistent on the reprimand. How far back can you go, and can you walk me through the process? I was trying to, has this occurrence happened before? What was the fine, reprimand, to be consistent from year to year?
With one particular individual or just with the
general.
board's decision as a
I mean, you
whole?
want to be consistent. If pharmacist did this, shouldn't it be the same fine? Be so we're consistent and
Right.
not reinventing the wheel, maybe?
I think we can go back as far as the board has orders. Consistency is something we strive for, but we also have to balance it with every case. The facts and circumstances of every case are different. There might be mitigating factors, aggravating factors. So we can go back, but something that also needs to be considered is the change in the makeup of the board over the years, and the board's stance at different times. So I think it's up to the legal team on that particular case. I generally, personally, I prefer not to go back too far, maybe the last 5 years. Is that fair?
Yeah, I'm trying to, we're relatively new, all of us, and trying to get a handle on, you're dealing with lives and, careers and
Right.
struggling to do the right thing, I guess.
Yeah.
To piggyback on that just briefly is that because we're not allowed to speak to other board members about a pending case, it's maybe direction on how boards in the past have tried to have more generalized discussions around maybe something like the concept of just culture or other, so that we have a sense of where we're at for different types of discipline that might come through, so that we don't get to the point where there's a stipulation agreed upon, and then it comes to the board, and then the board says, oh, we were either too lenient or too harsh, and we have to kind of undo all of that, I guess.
Right. And hopefully the staff in the division can really help you find out what the board has done historically, as well as give you the understanding for why you might be doing something that isn't consistent with what the board has done before. Just because you can't discuss the specific issues of a particular case with the board, you certainly as a group can discuss how you feel about certain activity. I know I've seen lots of times new developments in the profession, with this great recession, particularly in real estate. Now there's a lot of REOs and foreclosures and short sales, and real estate professionals not marketing those, but helping banks make sure pipes don't burst and things like that. And if they put a sign in the window, is that advertising when they don't have a listing? So new things develop in the profession too that need to be discussed by the board, and a determination made on how we're going to deal with those new violations. So I think I got off of your question, but.
Well, I think you answered it. I think if there's more, can we have some more prospective discussion globally to get a sense of where we feel is that minimum competence or what that minimum standard is, so that when cases come through, we don't get to the point where we want to have to go back and reopen and change stipulations that are.
Yeah, because you're in a closed session for a real short time, you're trying to deliberate and make a sound decision.
Right. It is challenging.
I just had a question of clarification. Did you say that under the circumstance of surrender, they can never get their license back?
Well, that's part of the negotiation. So sometimes they can, and sometimes they can't. Lots of different factors play into that. If the violations were so egregious, or this person just seems too incompetent, we may not want to allow them to come back. So it might be a revocation or a permanent surrender. But sometimes, I'm just trying to think of a circumstance, sometimes you just don't want to take it away forever. So they might surrender for 2 years or 4 years, but long enough where they have to then come back and meet all the initial licensure requirements, like education, testing, things of that nature.
But then it's written into a stipulation. If somebody just turns in their license because they say they're never going to practice in the state of Wisconsin again, there's no stipulation.
They can't resolve a disciplinary case by coming into the department and handing us their license. Can't do it. Has to be an order. It has to be an order approved by the board.
Thank you.
What if they beat someone to the punch and they come in and voluntarily surrender their license and then there's a complaint that comes up? Aren't they outside of the jurisdiction of the department at that point? If they say they're no longer practicing?
I've never encountered that circumstance. I was thinking where they might, maybe a complaint was filed, they know the complaint was filed, and then they come in before the disciplinary action really gets underway. And I believe the individuals in our credentialing, we all have access to the same system and the same database. The people in credentialing would be able to see that they had an open disciplinary matter and would probably alert someone in legal services and compliance and might not let them do that. We still have the ability, particularly if the license is expired, you have a 5-year automatic right to renew upon payment of a fee. So even if they have an expired license, we can still discipline their right to renew and actually put orders out, limitations on that. I've not thought of that. I've not seen that firsthand.
There are some employers that will say either you resign or you're fired, and they'll choose to resign.
Right.
I doubt it would happen very often, but
I guess I'd like some clarification as a citizen on that examination board. If I'm assigned a case that's not technical, and you were discussing with the individual here about...
Can you speak up a little bit?
And you were discussing with the individual up here about if we can't discuss, say if I assign a case and it's not technical to the veterinarian issue, and I can't discuss it with other board members, you had suggested that on a general basis, in talking with the legal team and or talking with, I'm a dairy producer, so I have access to other veterinarians. Am I free to discuss generalities to get a feel of, say, for example, impropriety or...
Sure. As long as you're not revealing any confidential information about the specific licensee, anything that you're privy to that you would know is confidential, you certainly can. Anybody else?
Does DSPS have any jurisdiction over people practicing professionally on the internet with Wisconsin residents?
I think it would depend on the board and what the board's statutes and regulations say. The example that comes to my mind, and I work on the non-health related cases, would be auctioneers. Some auctioneers conduct auctions live on the web. So the board interprets the definition of auctioneering to include that. Even though it's not live at an estate, it's on the web. So it just depends on your profession, statutes, and regulations. Anybody else? Thank you so much. I know it's probably been a long day and it's Friday afternoon, so thank you so much for your attention.